Hello, today talking about constitutional carry again, and today's statute is 30.05 of the Texas Penal Code, which is criminal trespass. I'm going to limit the scope of this video just on carry provisions. I'm not going to discuss just regular trespass situations. 2021 legislature modified 30.05 by adding subsection C and D3 and then amending sections D and F. So the basic statute is subsection A: a person commits an offense if the person enters or remains on or in property of another, including residential land, agricultural land, recreational vehicle park, a building, or an aircraft or other vehicle without effective consent, and the person, 1, had notice that entry was forbidden, or 2, received notice to depart but failed to do so. Okay, so that's basically what we're talking about here, but now we're going to talk specifically about if you are being asked to leave due to firearms, so that's the scope of this here. So the legislature added subsection C, which reads, a person may provide notice that firearms are prohibited on the property by posting a sign at each entrance to the property that 1, includes language that is identical to or substantially similar to the following. And again, I don't like when they add that substantially similar, because that's going to leave room for questions about what does that entail exactly. But the language is pursuant to section 30.05 Penal Code, criminal trespass, a person may not enter this property with a firearm, and that language has to be in both English and Spanish, appear in contrasting colors with block letters at least 1 inch in height, displayed in a conspicuous manner clearly visible to the public. So again, we're talking about a sign that says contrasting colors. I always say that glass with letters stuck to it is not contrasting colors, and it's not a sign, but that has not been tested in the courts, so proceed at your own risk if you see that. Subsection D was amended, and it reads, subject to subsection D-3, an offense under this section is 1, a Class B misdemeanor except as provided by subdivisions 2 and 3, a Class C misdemeanor except as provided by subdivision 3, if the offense is committed A, on agricultural land and within 100 feet of the boundary of the land, or B, residential land and within 100 feet of a protected freshwater area, and 3, it's a Class A misdemeanor if the offense is committed in a habitation or shelter center, on a Superfund site, or on or in a critical infrastructure facility. 3 goes on, 3B is the offense is committed on or in property of an institution of higher education, and it is shown on the trial of the offense that the person has previously been convicted of 1, an offense under this section relating to entering or remaining on or in property of an institution of higher education, or an offense under section 51.204B1 Education Code relating to trespassing on the grounds of an institution of higher learning, or C, the person carries a deadly weapon during the commission of the offense. Then they added D-3, which reads, an offense under this section is a Class C misdemeanor punishable by fine not to exceed $200 if the person enters the property, land, or building with a firearm or other weapon, and the sole basis on which the entry of the property or land or in the building was forbidden is that entry with a firearm or other weapon was forbidden, except that it's a Class A misdemeanor if it is shown on the trial of the offense that after entering the property, land, or building with the firearm or other weapon, the actor 1, personally received from the owner of the property or another person with apparent authority to act for the owner notice that entry with a firearm or other weapon was forbidden, as given through A, notice under subsection B-2A, including oral or written communication, or B, if the actor is unable to reasonably understand the notice described by paragraph A, other personal notice that is reasonable under the circumstances, and 2, subsequently failed to depart. Now, we've talked about subsequently before as a legal term. I think what they mean is immediately, but they say subsequently, and so the question always remains, if you subsequently leave, what does that mean? How quickly do you need to leave to subsequently leave? Now, Obviously, the smart thing to do if you're trying to avoid trouble is if someone tells you to leave, to just go ahead and leave and not test this, but subsequently does not mean immediately. E did not change, but it is important for you to know. So it's a defense to prosecution under the section that the actor at the time of the offense was 1, a firefighter or emergency medical services personnel as defined by 773.003 of the Health and Safety Code, acting in the lawful discharge of an official duty under exigent circumstances. 2, a person who was A, an employee or agent of, and then it goes on for a big long list, electric utilities, telecommunications providers, video service provider or cable service provider, gas utilities, pipeline for transportation or sale of oil, gas, or related products, or electric cooperative or municipally owned utility. So basically those workers, you can't trespass them. They have a right to do their job. Then B says performing a duty within the scope of that employment or agency. So those workers, while they're doing their job, you can't trespass them off of your property. Subsection I was not changed, and it's important because it says this section does not apply if the basis on which entry on the property or land or in the building was forbidden is that entry with a handgun or other weapon was forbidden, and 2, the actor at the time of the offense was a peace officer, including commissioned peace officer of a recognized state or special investigator under Article 2.122 Code of Criminal Procedure, regardless of whether the peace officer or special investigator was engaged in the actual discharge of an official duty while carrying a weapon. I'll be honest, I don't know why I-1 exists. It should just be I-2, because the way that reads is you could trespass a peace officer from your property as long as you weren't trespassing them because they were carrying a weapon, which seems to be dumb, but that's what the section says. Subsection F is for you folks with a license to carry, and it says it's a defense to prosecution under this section that 1, the basis on which entry to the property or land of the building was forbidden is that entry with a handgun is forbidden, and 2, person is carrying a license to carry under the license to carry statutes, and it's a handgun in a concealed manner or in a holster. And we've talked several times before, it just says in a holster. Don't be cute on this. I realize some of you like to put it in the holster and then carry it in your hand or put it on your car seat or whatever, and you're saying, well, it's in a holster. That might technically not be illegal, but that doesn't mean that you won't get arrested or cited. It doesn't mean that you won't be prosecuted. It doesn't mean that you might not even be convicted. So, proceed at your own risk if you want to try to bend the rules. There usually aren't many court cases that come up with these, previously 30-06 and 30-07. There was nothing defining some of this stuff. And this is basically worded the same way as those. So I don't expect there to be a lot of litigation over it. If you really feel inclined, you have the time and money, you can file for a declaratory judgment, get the courts to rule on what that means exactly when they say in a holster, and then we'll have some guidance beyond just the words of the statute. So why is subsection F important? It's important because we are going to have 3 distinct situations in Texas now. There's going to be the 30.05 notice, which applies strictly to the constitutional carry folks. Then there's 30.06 and 30.07, which apply only to the license to carry folks, one covering concealed carry and one covering open carry. Okay, so that's the distinction there. If you see the 30.05 notice, it's only applying to constitutional carry. If you have a license to carry, the 30.05 sign does not apply to you. And vice versa, if they have a 30.06 or 30.07 sign, it's not going to apply to constitutional carry. And that may seem weird, but you're going to run across places, especially initially, that have 1 sign or 2 signs, but not all 3. And it's over time, as they start getting told by their insurance companies or their lawyers that they need to put all these signs up, then they'll eventually have all these signs. But right now, I would expect that there's going to be places that have only 1 or 2 signs up, And obviously, if you have a permit, you're affected by the 2. And if you don't have a permit, then you're only affected by the 1. So you're just going to have to really pay attention if you're trying to avoid even the possibility of breaking the law here. The nice thing is, oftentimes these are more minor crimes, citations like a traffic ticket, but you do have to be careful. If you carry and are told to leave and you don't leave, then it usually elevates it to a much more serious crime. Interestingly enough, this one does not have the provisions that say, basically if they tell you to leave and you leave, then it's a defense. So that was missing from this statute that's in other statutes. They left in place F-1, F-2, F-3, and those are all basically the same sort of exemption. It just applies to residents of apartments, condominiums, leased premises, and manufactured home lots. So basically they are exempting you if you are in a place that you rent, you live at. They can't put up a sign that doesn't allow you to have a firearm on your possession. And those limits are going to be just like a lot of the other limits. It's going to be direct route from your vehicle to your home, from your home to your vehicle, and then obviously driving from the parking space to leaving the property, or from entering the property back to your parking space. It's not going to allow you to carry around the grounds, although other statutes may allow you to do that. Check out the 4602 video and see, you may have some sort of exemption from carry restrictions based on that statute, even if this one applies in other situations. So I think that's really all of the relevant stuff in 30.05 as far as carrying a gun without a license or with a license or as a peace officer. The rest of the statute just deals with the specifics of trespassing in general. Obviously, as always, if you have questions or comments, please leave a comment on the video. I do try to answer everybody that comments, and I will see you in the next video.